In this video, I'm going to answer the question, what happens if I violate my special conditions of bond? By the end of this video, you'll have an understanding of what would happen if you violated your bond conditions, how to know if you have bond conditions, and what types of things you need to do if you want to try to get those bond conditions changed. I'm Paul Ghanouni, founder and managing attorney at the teen and young adult defense firm, where we focus on helping protect the futures of people who are in their teens through their mid-20s when they get in trouble with the law. Now, this video is going to be kind of general information. It's not specific legal advice. It's not legal advice for your case. If you need specific legal advice for your case, please contact our office for a complimentary defense strategy meeting. So really, the first question that most people have is, do I have special conditions of bond in place? Different counties do it in different ways. Sometimes you go in front of a judge that's going to make it clear that you have special conditions of bond in place. That typically happens in Cherokee County, for example, and they'll give you some forms, and I'm going to show you an example here of what those forms look like. They'll go over those forms with you. Obviously I've redacted these so that confidential information regarding these people isn't out there. But that's the type of form that you're going to get from Cherokee County if you are put under conditions of bond. So usually with that, you'll go in front of the judge. The judge is going to go over with you what the conditions are, make sure you understand them, and notify you of those conditions. However, that's not how it's done in every county. Some other counties, sometimes you'll get conditions of bond without ever seeing a judge. They'll be put in place ahead of time. An example of that is Cobb County, and they'll just have it on their bond order form. And here's an example of what that looks like for you. So you can see that there's just got the information there. Obviously, I've redacted the case information, but it goes through, it tells you what you can do, what you can't do, and makes you aware of those. And here's just for another example so that you have the example is Fulton County's pretrial release conditions as well. So here's an example of what you might be looking for that. Obviously, these forms could change at any given point. The real key to knowing if you're under conditions of bond is to make sure that you take a look at all of the paperwork when you got out on bond. I know it can be a lot of information on that paperwork. A lot of it may seem like it's boilerplate, but it's really best practices to make sure that you know what conditions of bond you have, if you have any conditions of bond, and what you need to do to make sure that you're complying with those conditions of bond. If you were to violate a condition of bond, you could actually be sent back to jail with no bond, depending on the nature of the conditions that you violated. You could also, depending on the types of conditions, this usually applies to no contact provisions, and I've got a whole video that goes over no contact provisions and how to make sure you're not violating those. But if you violate a no contact provision, for example, you could potentially have new charges in addition to going back to jail for violating your bond conditions in the current case. Types of things that we see in bond conditions, just to make you aware, I'm just looking at these condition sheets that I showed you just as examples, that you not violate the law of any local, state, or federal law. So you could be in a situation that if you were charged with a new crime while out on bond, you could have your bond revoked. You're not drinking alcohol, not ingesting any marijuana, cannabinoids, or THC, not possessing or ingesting any illegal drugs, being subject to random drug and alcohol screens. Sometimes they'll tell you you've got to go get some sort of an evaluation done within a certain number of days, depending on the nature of the case. They might tell you that you have to, that you can't possess any firearms, that you have to keep your address up to date with the court, that you may have to reside at a particular address, that you can't have contact with certain types of people, that you can't have contacts with specific people, that you can't go to specific addresses, that you may have to report to some sort of a pretrial release officer. So there's a lot of things that can be in these conditions of bond. And sometimes these conditions of bond can impact your ability to see your family, they can impact your ability to work, they can impact your ability to do a lot of things in your life. And so if you're in a situation that you have these conditions in place, you need to make sure that if you need them modified, that you go through the right process to do that, which generally requires filing a motion in court, getting it scheduled for a hearing, and basically arguing in front of the judge as to why those conditions should be modified. Now, a lot of times attorneys, when we do that, we file those motions, we may talk to the prosecutor and see if we can come to an agreement before the hearing. But if you don't come to an agreement before the hearing, then you're going to be in a situation that you need to be prepared to argue those issues at a hearing and explain to the judge why you need your conditions modified. Now, if you're in a situation that you've got outstanding bond conditions, you're not sure if you've got bond conditions, you have a pending criminal case, and you need help for any reason, whether that's a criminal case, a traffic case, a DUI, a juvenile case in Georgia, please contact our office for a complimentary defense strategy meeting to see how we can help you with that case. Thank you.